So today, all cameras will be focused on the Court of Appeal. When the judges of the Court of Appeal, this particular bench that was constituted by the President of the Court of Appeal, Daniel Musinga, sits to listen to the appeal on the ruling against the BBI that was done by the High Court. The 7 judges are Daniel Musinga, the President, Kaido Gatembu, Fatima Sichale, Roslyn Nambuye, Francis Tuyot, Hannah Okwengu, Patrick Kiage. And those that will be in court are the President, Uhuru Kenyatta himself, former Prime Minister Raila Odinga, the National BBI Secretariat, the Independent Electoral and Boundaries Commission, and the Attorney General. And against the BBI will be the Kenya Human Rights Commission, the persons David Ndii and the others who had taken the case to court. We have Elias Mutuma for Third Way Alliance. We have other lawyers also who are representing other organizations as well. So this is now where everybody will be looking at and wondering, so what happens next? If the Court of Appeal agrees with the High Court, then the BBI is given another blow and maybe they seek to go to the Supreme Court. If the BBI is given a go-ahead by the Court of Appeal, then maybe those who are defending this at the Court of Appeal will go to the Supreme Court. So what happens? And then what happens to the fate of the basically BBI is, as we have this whole, legal conversation surrounding the legality of the BBI, the process, the technicalities of it. Do the people want BBI or do the people not want BBI? At some point, is it a decision that should be made by the people? And can we guarantee that the will of the people will actually be accorded its space if a referendum ought to be held today? In other words, can we really have a free and fair and competent and independent referendum being conducted in such a case where you can clearly see how much stake has been put by those who wield power? Many questions emerge there.
Absolutely. I mean, even as you're looking at, just as you're saying that, even as you go to court battles and such, the next 4 days, everybody's going to be held to grips and to try and understand the entire legal process in terms of what should happen. I am then asking myself, where is the will of the people in all of this? That did it actually come out clearly? Because it would seem as if sides have been taken, but one of the most important sides has actually not been taken into consideration at all. That nobody is asking, what do Kenyans want? Because this is what we are seeing here at the end of the day. When push comes to shove, is this what Kenyans want? Or are Kenyans at the point where they're actually going to reject this? It doesn't seem that comes into play. It seems that at the very last minute, when these decisions are made in court, then it will be thrown to Kenyans to chew it up for whatever is left of it and say, all right, we accept or we reject this. But right now, the will of the people not being considered, if you ask me. There are two sides that are fighting against each other. It would appear as though the side that has brought in this against that of the BBI initiative is fighting on behalf of the people. But I am left to wonder whether that really is the case. And when does the voice of the people ever get heard in things like this that would essentially change the way in which lives will be run in this country, and then you don't go to those people to ask for their approval?
The National BBI Secretariat will argue that it actually represents the voice of the people.
They will argue
that they got a good cross-section of Kenyans to support this by appending their signatures. Remember, they presented over 4 million signatures to the IEBC. They'll argue that this is the will of the people, and the will of the people shall be exercised even at the referendum. And so let's go to the referendum, where the people shall individually and independently make a determination on this and exercise their will. Express their voice on this particular move.
So having this shut down, essentially what they're saying is that you then deny the voice of the will of the people to be heard on this matter.
Yes.
So from that point of view, what the BBI committee would actually say is that if you don't allow this process to go through, you're not allowing Kenyans to actually say what it is that they want. I think it can be argued on very many sides. Because really, did the voice of the people come out when this was being put together in the first place?
Let's bring in constitutional expert. Our friend Waikwa Wanyoike joins us this morning again. Good morning, Waikwa.
Good morning.
It's good to have you on the show. Welcome to the Situation Room this lovely Tuesday morning.
Thank you for having me, Eric and Waikwa.
Good morning.
So the hearing at the Court of Appeal begins today. Various people have various issues that they're raising, and there were 17 issues on ground for appeal. Just from the very onset, we discussed this when the High Court judges made their ruling and their determination. What should we expect in the next couple of days in terms of arguments 2 and 4, for and against?
We expect a lot of fights, especially from the government side and the BBI, the promoters of BBI, who, by the way, are one and the same thing. As you know, there are quite a number of issues, as you said, but there are some issues that are probably considered more important than others. Just to highlight a few, there is the question about popular initiative. What is a popular initiative, and who has the right to initiate a popular initiative? That question is important for 2 reasons, at least. One, because if the Court of Appeal agrees with the High Court, then the entire process is found to have been unconstitutional from the beginning. But the second reason why it is important is because it's for the purpose of initiating a popular initiative, which the judges found to have been done against the law, that Uhuru Kenyatta was also found to have violated Chapter 6. And so that is an important issue, especially also for the president, to be able to get to the point where he might be able to reverse that finding, if at all. The second issue that I think will be very, very contentious is the issue about basic structure doctrine. The appellants, and this is the BBI and the Attorney General, are saying that this is a foreign creature that was initiated by the judges, all invented by the judges, that the Kenyan Constitution doesn't have a basic structure, and so it was wrong for the courts to confirm that. And in fact, what some of them have argued is this is what is called judicialization of politics, basically judges taking over politics. So we expect a significant fight about that. And why that issue is also important is because first, it's so critical in terms of the future amendment of the Constitution, because then whenever one proposes to change the Constitution, whether it's Parliament or through popular initiative, there is always going to be that question, is what you're changing a basic structure? And so is the process required a different one? But it's also important because if it's found that there is, or again confirmed that there is basic structure, then the question goes specific to BBI. What provisions did you choose to change that affect the basic structure? So it gets, again, quite messy. The third issue is what we call what is an amendment. By the way, there is this belief that the only appeals that have been filed are appeals that have been filed by those who are supporting BBI. In fact, even those who substantially won have also filed what we call grounds of affirmation or counter appeal. And so one of the issues that is critical is what is an amendment. So is it right, if you're amending the Constitution, to pack so many issues in an amendment bill? Or is an amendment required to be only one singular issue? Remember, Eric, why this issue is important is that if you allow more than one singular issue, and by a singular issue I mean issues that are related, as opposed to having multiple different issues that speak to different things, like the BBI bill is. Then if you allow more than a singular issue, what we call an omnibus bill, then the question becomes, how can you stop somebody who is proposing to amend the Constitution from using an amendment power to actually replace the Constitution, or, as some of the respondents are arguing, to dismember the Constitution, so that tomorrow you can just come up with an amendment, an initiative that says Amendment of Kenya 2021, Constitution of Kenya 2021 bill. The Constitution of Kenya is amended by replacing the following, and you list from provision 1 to the last provision, which is provision 260. And then you bring your own and say this is an amendment, because to some extent that is what BBI tried to do, and maybe went, maybe not halfway, but at least quarter way there. Then there's two probably other issues that are that will be very, very contentious. There are issues relating to IBC, issues about quorum. But that may not be as important because now IBC recruitment is happening. But issues to do with signatures. What is a signature and how do you verify that? And whether IBC actually had conducted voter registration and whether it was in default, that will be important. Then finally, obviously, the issue about whether the president can be sued. So those are some of the issues I expect to be very, very contentious. Those issues obviously lead to other questions. And one of those very important questions is, if you allow an omnibus bill, then should you be having a multiple, should you be having multiple questions at a referendum, or a multiple question referendum?
Right. Waikwa, this is a unique, presenting another unique situation whereby executive is directly involved then again in judicial matters. Do you think that there is heavy pressure on the judiciary right now to adjudicate in this matter along the lines or along the preferred lines of the executive?
Certainly, and you can see it at two levels. The first, obviously, we saw what the president said during the Jamhuri Day celebration. It was a lot of us believe that that was a message that was specifically calibrated for judges to tell them that you cannot nullify a process that I've started myself, because the president claims to speak for the people. So that is one. And maybe added to that, the appointment of judges, where the president obviously failed to appoint 6 judges, 2 of whom were in the BBI. And people have forgotten that there were, out of the 5 judges, only 2 of them had been selected for the Court of Appeal, not because the others were not selected, applied and were not selected. It's because they hadn't applied to go to the Court of Appeal. But Justice Joel Ngugi and Justice Odunga applied, and they were interviewed, and they were selected. And the president coming and making that partial appointment so soon after BBI judgment and leaving those 2 judges, it's hard not to read that was animus from the president, because the 2 judges ruled against him. And I hope Kenyans don't forget that. But the second main reason is the lawyers that the government and the BBI team has chosen. As you will notice, starting with Attorney General. So we have a whole state department that has many, many lawyers, hundreds of lawyers. At the High Court, those the Attorney General was represented by lawyers who are staff members at the office of the Attorney General.
Mm-hmm.
The Attorney General has now chosen to go to private bar and hire, obviously, very senior and very experienced lawyer. Of course, there are questions there. What message is the Attorney General sending to the people? Is it that he's saying his lawyers at Sharia House are not good enough, they are not competent enough, they are not good fighters? That's a question for another day. But the fact that he chose to go to private lawyers who are big names, that tells you they are not leaving anything to chance. And that happened also with IBC. I understand, for example, the former Attorney General, who is still a public officer, by the way, because he's a member of one of the corporations, has joined the IBC team. And we know the list goes on in terms of heavyweight. Interestingly enough, when you compare and contrast, it's almost that fight between David and Goliath when you look at the profile of lawyers on the two sides.
Yeah, let's look at those lawyers actually again, because like you say, very senior lawyers and heavyweights on the one side, those that are appealing these decisions of the High Court. For the president, we have senior counsel Waweru Gatonye, Mohamed Nyaoga, Desterio Yatsi, Tom Masharia. Then for the BBI Secretariat, you have senior counsel James Orengo, you have Otiende Amolo, Paul Mwangi, Ben Sihanya, Jackson Awele, Arnold Oginga. You have for IBC, Professor Gedho Muigai, Eric Gumo. For the Attorney General, we have the Solicitor General himself, Kennedy Ogeto. And then you have George Oraro, Paul Nyamodi, and Kamau Karori. These are big names that they've put together. They've said, we are going all out. So there's a lot of investment on a positive decision coming out of this. If you look at it now from the political side of things, when you see the president, the former prime minister, the machinery in the state has actually put together such a heavy team, if a decision were to go against them, politically speaking, and this is looking at the reality of what we have seen in this country for many years, what is the likely political response to a negative outcome out of this particular case?
First, before we go to the political reaction, just a few things about the lawyers. Kenyans should not be too worried that the state side and the BBI side has big names. We should also list the lawyers on the other side. But I'm sure a lot of Kenyans won't recognize those names, other than maybe the name of
John Hamiswa,
John Haminwa, and to some extent our president, Nelson Havi.
Yep.
Once you start going down the list below that you don't recognize, Kenyans won't necessarily recognize this name. They're not household names. But Kenyans need to know. I've worked with all these lawyers. I've had the chance to litigate with them and against them. Both the big names and for lack of a better word, the small names. These unknowns are brilliant constitutional lawyers. Remember, this case is about, when you take politics out of it, it's actually about very technical constitutional issues, what we call groundbreaking type of constitutional issues. If there is brilliance in the room, and if Kenyans are watching for brilliance, not drama, they should be watching the respondent's lawyer. That is where the good arguments or the very deep arguments will come from. These are people who spend a lot of time thinking about constitutions, not about just Kenyan constitution, but comparative constitution. A lot of them teach law, and so they are extremely brilliant. And when you're dealing with an issue that is being litigated the first time, you want somebody who reads their law, who reads other people's law, who understands how these things have developed, not somebody who brings the weight of their name to the courtroom. Yes, they may be seen when you watch the courtroom. You may see those senior counsel get a bit more room, a bit more deference from the judges, because that's natural. But when you listen to the argument, then you'll know who has the stronger and more sophisticated argument. So I wouldn't worry about that. And having said that, actually, it's quite ironical. Again, I say that I've worked with lawyers on both sides. On basic structure specifically, the BBI case is not the first case that determined that the Kenyan 2010 constitution has a basic structure. The first case actually was decided in 2012 by Justice Lenaola. And that was a case when members of parliament were trying to take themselves out of the definition of a state officer because they wanted to make sure that their salaries and emoluments are not regulated by Salaries and Remuneration Commission. The two lawyers who argued that the Kenyan constitution has a basic structure, and Justice Lenaola agreed with them, even without necessarily elaborating to the length that we saw in the BBI, were senior counsel George Oraro and Mr. Paul Nyamondi. I was lucky to argue alongside the two of them for Katiba Institute that the constitution has a basic structure. So you can see, even some of these contradictions will come out.
We are talking about the case that's about to begin at the Court of Appeal today. The 7 judges of the Court of Appeal will be hearing arguments for or against the appeal on the BBI ruling that was done by the High Court. Waikwa Wanyoike, constitutional lawyer, is helping us go through this. In the room with you this morning is Nduokoa and Eric Latif. The headline in the Standard this morning: all eyes on the 7 appellate judges who will determine the mother of all court battles. It's basically been billed as the big one. This is it. This one determines the shape of the country coming into the next general election and beyond. And when we were talking about all the things that we were discussing earlier, Waikwa, you said, for example, on the matter of whether the constitution has a basic structure, some of these lawyers who are today representing the Attorney General were on the one side arguing at some point, and you said they argued, and you were part of that, on the issue that there is actually a basic structure to this constitution. Now, there are questions. I want to ask a question that I've seen that has been asked on social media. Somebody's asking, so of all these lawyers, of all these interested parties, and let me just repeat, there's lawyers representing the president, lawyers representing the former prime minister and the National BBI Secretariat, for IEBC, for the Attorney General, and those on the other side of the divide, lawyers representing the Kenya Human Rights Commission, David Ndii, and the others who also had taken their court. Among them is our friend Wanjiru Gekonyo and Cherotich Sei, Elias Motuma for Third Way Alliance. Then there are lawyers Dudley Ochiel, Morara Omoke, Michael Karanja, Modomi Diankolu, and he said also Senior Counsel Martha Karua, and others. Who represents the voice of the people? Or are the people, is there any entity called the people here that's going to be represented in this case?
The people sometimes is a political construct, or a construct of politicians, actually, to put it much more precisely. And so it's always contested. For me, I would want to ask, are there lawyers for the Constitution and lawyers arguing to frustrate the Constitution? And if I was to answer my own question, I would say yes. The people who are trying to uphold the Constitution, using what the Constitution states in Article 1 in terms of sovereignty of the people, Article 2, supremacy of the Constitution, Article 3, defense of the Constitution, and finally, Article 259 on how the Constitution should be interpreted and its purpose. Those are the people who are acting for the Constitution. By the way, there are two lawyers that I think it's important to highlight who are representing the respondent. The first one is lawyer Caroline Kituko. She's the main and only lawyer for the Muslim for human rights. Remember, Muslims for Human Rights have brought a very critical issue, which is the question about the legal framework, whether there is sufficient legal framework to guide the constitutional amendment. The second one is a lawyer called Muthoni Nyiguto. She's the lawyer who is representing the law professors who joined the case at the High Court as amicus. Why do I highlight that? Because if you look at big public law cases in Kenya, they are cases about testosterone. And there is a way that the legal profession is guilty about minimizing the role of women lawyers. And I think it's important to celebrate these lawyers. If you look at the other side, I have hardly seen any woman, leave alone a woman who is unknown in the legal profession, not very well known in the legal profession. And I think it's important that even when we litigate these cases, we also are able to see the values that we are trying to imbue through the cases. But thinking about your question about the implications, Latif, where we sort of posed the conversation. I think there are two levels of implications. There is the political implications and there is the legal implications. Let's start with the legal implications. The legal implications are a bit complicated. There is a very good possibility that the Court of Appeal will agree with certain issues that the High Court ruled about and disagree with certain issues. There is also a third possibility that a lot of the people are not discussing, which is that the Court of Appeal could actually enhance some of the findings of the High Court. To give you an example, the High Court said what is required at a referendum is to pose multiple questions. If BBI bill was to get to a referendum, then you have to pose multiple questions and not a single question. The Court of Appeal could come out and say, actually, one of the problems of BBI was that you packed too many issues in the bill. And so it was wrong from the beginning to do that. And if you wanted to amend the Constitution, or if you want to amend the Constitution in the future, you have to only take one issue. That would be what we call an enhancement of the finding of the High Court. But let's assume that some of the different losses for those who won at the High Court. There is obviously the first question: is it possible that the judges can reverse all the findings? Of course, legally or conceptually, it's possible. But is it likely? I really doubt that it's likely that the judges will reverse all the findings. Why is that important? Because if you look at BBI, because it's been presented as a package, if they lose on one of the issues, let's say they win the 14 or 15 issues out of the 17, but they lose 2 or 3. And let's assume, for example, they lose on the issue of the 70 constituencies. It almost certainly means they can't take the BBI bill to referendum, because the BBI bill is inseparable. The different provisions are inseparable. It's one bill. So the question, and this is the legal implication for me, in terms of the first question, is winning in the Court of Appeal allows for a referendum, because that's what the winners want.
So Waikwa, essentially you're saying that in terms of determining this case, that if it's either you deliver for the BBI in its entirety, and you're not, because if you cherry pick amongst the issues, you're essentially dealing it a blow. You have to take it as a full package or not at all.
That's correct, Duoko. Let me give one other example. Let's assume the appellants win on the issue of of basic structure, and the Court of Appeal says actually Kenyan Constitution doesn't have a basic structure. The High Court judges were wrong, but then they lose on the issue of popular initiative, that the president and state officers and public officers cannot be involved in propping a bill using state resources additionally and call it a popular initiative. What is the implication of that from a legal standpoint? It means that the bill is still defeated, because BBI bill, even though the question of basic structure they succeeded, still they failed on
the threshold of popular
on
initiative.
the question of the threshold of popular initiative. And you can say that with almost every example, whether the verification by IBC was wrong, then the question there is if the court confirms that everything else, but says actually the only thing is IBC, the way you verified the signatures was wrong. So you have to go back to the verification process. So you're not, again, leapfrogging to the referendum, which is what the appellants would want. But then I say there is also the political implication. So we can discuss. There's more to discuss in the legal implication. But let me just highlight the political implication. Obviously, the first question is, can we expect political backlash against the court from the judges, from the politicians, rather? And certainly, again, when you look at that, what some people may call stellar cast of lawyers representing the government, in this case, of course, they are not looking to win, to lose. So there will be significant disappointment. And so you might hear politicians again go to what happened after the High Court and maybe the 2017 presidential scenario. But it may be less this time, because again, this case is not ending at the Court of Appeal. It's going to the Supreme Court. So whoever loses here, and especially the politicians, they feel like maybe they have another chance at the Supreme Court. And so they may wish to temper down their frustration, or at least their public outrage as they wait for the Supreme Court.
So, I mean, if we're looking at scenarios now and how they would play out, I mean, let's look on the other side of it, and everything goes back and you have to restore factory settings. What would you predict for your political situation in the country whereby, BBI is not front and center in terms of conversation anymore? And then there's the insistence then on implementing the Constitution as it is.
In fact, my own prediction, Waikwa, is that we are going to factory settings very soon, sooner than a lot of people believe. If the appellants, and that is the government again, and the president and Raila Odinga, fail to succeed at the Court of Appeal, it becomes nearly impossible for them to hope to succeed at the Supreme Court. One, because it's very difficult to say that two lower courts on such a technical and difficult questions were totally wrong, and Supreme Court comes and overturns everything. It's extremely, extremely difficult. So they know that if they don't win now, they basically likely have lost the Supreme Court. Of course, they will keep fighting if for nothing else to save face. But the second reason why we will soon be going to factory setting is because we are getting to a situation where the people start wondering, are we going to focus on BBI, or are we going to focus on 2022 elections? Yeah, we are getting very close. As you saw the other day, IBC already issued an informal calendar about timelines, and even certain activities that relates to actual election have to be completed as early as March next year. You've seen the deputy president say, let's just do the elections. Let's forget about referendum. Let's forget about distraction. We've seen the former vice president Kalonzo say we must have elections in August, the second Tuesday of August 2022. So And what is not negotiable constitutionally is the date of the next election. That is set on stone, on constitutional stone. BBI and the referendum is tentative. Remember, we are only litigating process issues mostly. We have not even started litigating substantive issues. And what do I mean by that? What we've been litigating is whether the processes that were followed were right. If, for example, the appellants win at the High Court, at the Court of Appeal and the Supreme Court, there will be more litigation. Asking, for example, is including a judiciary ombudsman right? Is that constitutional, right? Is what Parliament did in terms of saying certain sections of the bill are unconstitutional and certain processes are suspects, and then going on to pass a bill, was that constitutional? There will be question about something that a lot of people don't talk about, how the BBI chooses to treat the removal of Director of Public Prosecution. The issue about the police and the National Police Services and how it's treated. So there are so many substantive issues that will also be litigated. And by litigating those issues, it's very likely that will again restore BBI. So if there's anything that is very, very tentative, it's actually a referendum, almost a non-given. Certainly, we can't have a referendum by 2022. And to the extent that we don't have a referendum by August 2022, we'll get a new president because Kenyatta's term is over. Then is a new president going to be coming in? Even assuming it's Raila Odinga, is he going to be coming in and the first thing he wants to do is to get into a toxic conversation about changing the constitution? I highly doubt it.
So then why do you think the politicians are maintaining and saying this cause? Isn't it apparent to them, just like the way it is apparent to you, that, look, from where we are right now and the date of the next election, it's almost impossible for us to achieve what we are calling the constitutional moment, for us to amend the constitution? Or is this just a political tool that is, keeping Kenyans busy and creating what we call now the political divides, where it's clearly seen these are the people who are for the constitution amendment, they are on one side, and these are the people who are lukewarm on the constitutional amendment, they are on the other side, and then there are a few people who are against the constitutional amendment on the other third political side? Is this just a political game then?
So maybe 2-3 points on that question, Eric. Do they see what we see? I think they do now. I don't think they saw it when they started this process. I think they got really bad legal advice. But secondly, they came with the arrogance that because they're the politicians, they are in power. And remember, this process saw the merge or closing of ranks of the two main politicians in Kenya. And I don't think at that point they had the arrogance that we fought separately. Now, if we combine our power, there is nothing that can stop us. They forgot there was a constitution to stop them. So they came with that arrogance. But why do they still want to keep going and investing so much now? Of course, because there are certain things which are at stake. The first one is obviously there are certain things I think genuinely they would want to reverse. If you look at the way the appeals were filed, the appeal that is filed on BBI, the issues about BBI, popular initiative and all that, that is mostly filed by Raila Odinga and the BBI secretariat. The president actually hardly touches issues about BBI and whether it was there is a basic structure and things like that. The president's appeal mostly centers on himself. The fact that the court found that he had violated Chapter 6 and that he could be sued. And even looking at who appealed what, you can tell what the different people's interests are. So Raila is really determined to save BBI, and so all his lawyers, that's all they're focusing on. The president is very busy trying to save himself. He forgot the entirety of the other parts of BBI. IBC has appealed on the issues of signatures. It's appealed on issues of its own quorum. IBC has not appealed on the 70 constituencies because IBC knows that what BBI was trying to do on the 70 constituencies is illegal. Of course, the BBI Secretariat, because the BBI Secretariat and Raila Odinga are trying to use BBI as a vehicle for political mobilization, they've appealed on the 70 constituencies. And that is the third, that takes me to my third point. The other and the main reason, especially for Raila Odinga, in my own view and in my own speculation, is because BBI has actually been good for him as a political tool of mobilization, where the state is able to use resources and he can ride on that wave. Remember, one of the bigger issue or one of the bigger problems is that BBI has been funded through state resources. Running campaigns obviously is expensive. This has given Odinga a platform largely paid or facilitated by the state, and for somebody who looks to continue remaining relevant so that he can contest the presidential election, to some extent, there is still something to be gained by keeping BBI alive, even when he knows that it's going nowhere.
Waikwa, thank you very much, as always, for joining us and for clearly articulating the issues so well to us. Asante sana. Waikwa Wanyoike is a constitutional lawyer. He's been telling us what to expect, the battles and then the expectations as this battle goes to the Court of Appeal. 7 Court of Appeal judges will begin today hearing cases for and against the BBI process. Thank you very much, Waikwa. Have a lovely day.
Thank you
Thank
for
you,
inviting me.